Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, December 26, 2019. The time is 9:10 a.m., and we are meeting in the Hearing Board room in Diamond Bar. We have one matter on our calendar for today, and that is Southern California Edison, case number 1262-112 for an interim variance. And who is representing Southern California Edison this morning?
Good morning. My name is Kelly O'Donnell Henderson. I'm a senior attorney at Petitioner Southern California Edison.
Thank you. Has your name changed since you last?
No. Well, I don't. I'm trying to remember the last time I was here. I got married in 2010, but didn't change my name until I had the kids, and that takes forever if you don't do it on your marriage license. I discovered you have to file a petition with the Superior Court, and they do a background check.
Aware of this,
Oh.
having changed mine 3 times. Not 3 marriages, but 3 times.
So I've added I tacked the Henderson onto the end. So
Gotcha. And do you, Madam Clerk, do you need a spelling on that, or you're good? Okay, thank you so much. And who is representing the executive officer this morning?
Mary Reichert on behalf of the executive officer.
Good morning, Ms. Reichert. Okay, we're going to bifurcate the hearing today because we are hearing an interim variance, so there is no notice to the public of today's hearing. So the first part of the hearing will be to determine whether there is good cause to proceed in absence of notice to the public. And would you like me to call you Ms. O'Donnell Henderson?
Henderson is fine.
Henderson is fine? Okay. So Ms. Henderson, would you like me to go over the 4 elements that we determined for good cause, or are you familiar? I can't recall.
I mean, I'm familiar with this. I think actually, why don't we go over it again?
Okay, why don't we do that? So essentially, we're just looking to see whether there is no possible way that we could have had a noticed hearing. So what we're looking for is that there is a violation, or that violation is imminent before a noticed hearing could be held. That the circumstances that led, so that's number 1. Number 2 is that the circumstances that led to the violation could not reasonably have been avoided by petitioner, or, and it's all part of the same one, anticipated in sufficient time to have a noticed hearing. And we're talking about short variance hearings, so generally the time frame from filing a petition to having a hearing is about 21 days on average. The third is that diligence was exercised in filing as soon as petitioner knew or should have known that a variance more likely than not would have been needed. So we're really looking for quick filing. And finally, the fourth is that a denial of the interim variance would result, I think in this case, in an unreasonable and unavoidable adverse impact to the petitioner. Okay. So first I'm going to ask that anyone who wishes to testify or give evidence today in today's hearing to please rise at this time to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. And Ms. Henderson, if you would like to give an opening statement, and we'll try to keep it to good cause as much as possible.
Yes. I will start, as you requested, with our demonstration of good cause, and I'm going to be calling 2 witnesses, and I just wanted to provide a very brief introductory statement to sort of place everything in context. This matter today concerns Edison's Berry Peaker. That's one of 4 of our peaking plants in the South Coast Air Basin that provide power during times of peak demand. We have a 5th peaker in Oxnard. Berry is a 49 megawatt electric generating unit that relies on an engine called the LM6000, and all 5 of our peakers have the same model of engine. Now, ordinarily, the Berry peaker has 1 annual source test for ammonia, and that requirement is in our permit. Because we did some upgrades in the 4th quarter of 2018, the requirements for source testing were different in 2019. We had 3 source tests required, 1 in the 2nd quarter, 1 in the 3rd quarter, and 1 in the 4th quarter. We complied with the second and the third, and we're here today to talk about what happened with the fourth quarter. And we're here to request relief from the fourth quarter testing requirement. The deadline for that is next Tuesday, New Year's Eve. And unfortunately, the unit will be out of service until at least January due to unforeseen damage. And since that deadline is next week, we obviously did not have enough time to provide the 15 days of public notice before December 31st. So we have a short variance hearing on calendar for January 14th. And so today's interim hearing, we will explain why the problem was unforeseeable under the circumstances, and that denial of our good cause, our showing, would result in unavoidable adverse impact. And so I have two witnesses to call, Terry Maddox and Casey Scott. So if that's agreeable, I would like to call Mr. Maddox as a witness.
Yes, I'm going to first turn to Ms. Reichart for her opening on good cause, but I just wanted to note, as you stated for the rest of the board, that we did receive an email and requesting a one-time rescheduling.
Yes.
And so the short variance, even though it says on the front of the petition, it says that it will be held on the 7th of January. In fact, it is now scheduled and has been noticed for the 14th. And I'm going to mark, if everybody has it, that email as Exhibit 1 so that we have it in the record. But that will be a relevant date for our consideration of the 4 findings we need to make for good cause. And I'm sorry, Madam Clerk. Oh, you don't have it?
It was in our inbox.
It was in our inbox, so I'm going to give mine to the clerk.
I think with your package.
We can do it later. Yes, and the only relevance of it is the date. So as long as we all take note of the date, because when we determine in the 4th factor in particular, unreasonable and unavoidable adverse impact to petitioner, the time frame we're looking for is until a noticed hearing can be held. And in this case, that will be on the 14th of January. So we're just going to take note of that. Not the 7th, the 14th. And while we're marking, I'm just going to mark, even though we wouldn't take this up until we get to the merits, but we have proposed variance conditions, which were just handed out, and we'll mark those as Exhibit A as an apple for the district. And with that, I will turn it to Ms. Reichart for your opening on good cause.
Thank you. The district is not opposed to a finding of good cause. Thank you.
Thank you. Okay, so Ms. Henderson, you may introduce your first witness.
Okay. Would Mr. Maddox please join us? Good morning. Could you please state and spell your name?
Yes, Terry Maddox, Terry, Terry, Maddox, Maddox.
Are you testifying under oath?
I am, yes.
What is your current position with SCE?
I'm Principal Manager for Generation Eastern Operations.
In general, what are your current job responsibilities?
I lead the team that's responsible for routine operation and maintenance of our facilities in the Bishop Mono Basin, Catalina, and Los Angeles Basin areas, including all of the units that are regulated by South Coast Air Quality Management District, which includes the Berry Peaker, which is the subject of today's discussion.
And are you familiar with the variance petition that we're discussing today?
I am, yes.
And as I think you just stated, you're also familiar with the equipment that is the subject of this variance petition?
Yes.
Okay. Please describe the facility that's the subject of the petition.
The Berry Peaker is a gas-fired combustion turbine facility that has 2 primary purposes. It's mission critical to the support of the electric grid. It provides short-term energy capacity needs on a short-term basis, and also
I'm sorry if I can interrupt, Senator.
Madam Chair, it was suggested at some point, if at all possible, that you brought a schematic in and described the operation. Did you do that?
We have some photographs that we'll produce later. We do not have a schematic of the
Operation?
operation. That can certainly be provided, but don't
What
have
about
it
the
available
photographs
today.
as he speak?
If it would be helpful to introduce those early on, we could do that.
Sure.
Okay.
I can do that right now. I would ask the clerk, I have 3 photographs that I'd like to introduce. I have 10 copies of each, and so I don't know if my email was Exhibit 1, would these be Exhibits 2, 3, and 4?
Yeah, I'll mark those, but if you make sure that Ms. Reichart also has a copy. Thank you.
And these are 3 photographs. One depicts 3,
We will,
Okay.
I'm sorry, I appreciate that, Ms. Henderson, and let's get to that, but let's make sure we all have them in front of us first.
oh, whoops, it's a little
Pesky
paper clips, I know.
Thank you. Oops. Thank you.
Right. And then let me give you a copy. And I'll just look off yours, I don't need my own, so that leaves 8. 4. So we'll do them in this order. Thank you very much.
Let's just take a moment just to allow the clerk to put them together.
Thank you very much.
Okay, for ease, so we don't have to describe them and we can just have them explained by the witness, I'm just going to staple these 3 photographs together and we will mark them as a packet as exhibit number 2. And you may proceed.
Great.
Okay, the Barry Peaker facility has 2 primary purposes, both of which are mission critical to the reliability of the electric system in Southern California. One is to provide short-term capacity. The unit is capable of remote startup with 10 minutes advance notice from 0 to full load operation. It is also a black start unit, so in the event of a regional blackout where there's no external power supply, this unit can start up and synchronize to the grid and assist with restoration of the grid in the event of a regional blackout condition.
So you've described the facility in general. Can you now tell us about the specific equipment that is the subject of the variance petition?
Yes, the specific equipment involved in the petition request is emissions control equipment and support systems on the exhaust of the engine with the purpose of controlling NOx emissions.
And is this equipment known as the SCR, selective catalytic reduction?
Yes, the technology that's used is an SCR, selective catalytic reduction, which uses ammonia to activate a catalyst layer within the SCR module, which enhances capture of NOx molecules in the exhaust and thereby helps to reduce NOx emissions.
Now, I'd like to just have you briefly describe the 3 photographs that were just marked as Exhibit 2 and distributed, so if you wouldn't mind doing that.
Okay, the first photograph shows the engine, which includes both stationary and rotating elements within it, that has been removed from the machine. The purpose of this photograph was to illustrate that this engine is very similar to an aircraft engine. So a 747 aircraft utilizes an engine that is very similar to the one that's illustrated in the photograph. This shows, relatively speaking, the size of the components involved with, there's perspective there between the people and the engine itself, so you can get an idea of the size of that particular component. The next photograph shows some discovered damage that occurred inside the engine, in this case in a turbine blade that appears to have been damaged by impact from upstream particles that were liberated in the machine. And then the third photograph shows one example where the metallic material that was liberated from, in this case, a stationary turbine blade. We also know that there was metallic liberation from a fuel nozzle, that those metal particles that broke free traveled downstream and impacted the other location illustrated in the prior photograph and caused the damage that was discovered.
And these photographs, they're enlargements, correct?
Yes, each photograph, each of the, well,
Second and third,
photographs
the
2
second and
and
third
3.
photographs,
Yeah, photographs 2 and 3 illustrate discovered damage, and these photographs are largely are enlarged to provide a better picture of the extent of the damage, the location, and the geography of the damage. So, in both cases, the damage area appears much larger than it really is because of the magnification that took place in the photography.
And can you just give us a ballpark sense of the size of the actual damage?
Yes, the size of the actual damage in the photograph is it's roughly 3/8 of an inch across. So this impact damage that looks like a gouge in the turbine blade, the full extent of that is 3/8 of an inch or less, to give you a perspective on the actual physical size. Same thing with the other photograph. It's much smaller than it might appear in the picture.
Okay. So now I'd just like to take you back in time a little bit and ask you a few questions about some work that was done and how this was discovered. Oh, but before I do that, are the combustion engine and SCR critical for Berry operations?
Yes, all of that's necessary for operation of the unit.
Okay. Did Berry undergo an upgrade of its SCR system in 2018?
Yes, it did.
And when did that occur?
That work was completed in December 2018.
And what was the purpose of that upgrade?
There were 2 primary purposes associated with that upgrade. One had to do with the life of the prior catalyst in the SCR. It was nearing end of life and was beginning to exhibit less than full effectiveness. So we needed to replace the worn catalyst with new refreshed catalyst. And at the same time, we were anticipating upgrading the unit so that it would enhance its NOx removal capability. So we actually not only replaced the catalyst, but at the same time upgraded it with a more effective catalyst layer.
And
Sure. What
Senator?
year, what the date was that? What time and date?
It was December of 2018
Thank you.
that work was completed.
Thank you.
And were these upgrades expected to have environmental benefit?
Absolutely, yes. They were expected to enhance the capability to control NOx emissions.
After the upgrade, did SCE notice any performance issues with the SCR system?
Yes, we did experience some difficulty with the the SCR system following the upgrade. It was experienced on an intermittent basis. So at times during unit operation, the NOx removal was not being controlled per specifications, and we would have to resort to taking the unit out of automatic control and utilizing manual control with operator intervention to maintain NOx emissions compliance.
And did you take any steps to troubleshoot these problems in 2019?
Absolutely. Throughout 2019, whenever we had an opportunity with the unit in operation, we would capture data, and we would assess the operating performance of the equipment. Again, as I mentioned, it was an intermittent problem. So sometimes we would run the unit and all appeared well. At other times, we would be operating the unit and we would experience difficulty, and so we would capture data from those difficult evolutions and then apply countermeasures that involved adjustment of various tuning constants in the control system and other countermeasures to improve the operation throughout the course of 2019.
And did you also contact the manufacturer of the equipment for input?
We did. We reached out and we engaged the original equipment manufacturer for support. We utilized internal subject matter expertise from the control side as well, and collaboratively worked on identifying the root cause of the problem and implementing agreed upon solutions.
So even after all of this work, were you still having problems with the SCR in November 2019?
Yes. Despite all the efforts that we had undertaken throughout the year, in November 2019, we were still experiencing occasional problems with NOx control.
And was there a source testing requirement in the fourth quarter scheduled?
Yes, there was.
What was the date that the test was scheduled for originally?
It was originally scheduled to take place on November 14th, 2019.
And did the test occur on November 14th?
It did not.
And why did it not?
We were still encountering some difficulty that would require us to resort to manual operation to maintain NOx compliance. And the source test requires full automatic operation. So we were not optimistic we would be able to conduct the source test in full automatic and successfully maintain NOx compliance. So we opted not to execute the testing at the original time.
And what was the date for which the test was rescheduled?
It was rescheduled to December 18th, 2019.
And did you also have any, let's see, so were you optimistic that the SCR issues could be resolved in time for the rescheduled test for December 18th?
Yes, we were originally optimistic that the countermeasures that we would apply and the work that we'd done would allow us to achieve a successful test on the revised date, testing date.
And so between when the original test date was scheduled and the revised and the rescheduled date for December 18th, did you continue to try to improve the system and solve the problem?
Yes, at every opportunity, we continued to capture data and identify potential corrections that could be implemented throughout that entire sequence.
Okay, thank you. Now, at the same time that you were dealing with these SCR issues, did it also happen that you had a planned maintenance outage scheduled?
Yes, that's correct.
And what were the dates that the outage was scheduled for?
That outage was scheduled to commence on December 3rd, 2019.
And when was it scheduled to end?
The original outage end date, I don't recall what the
When
outage.
did it end?
Yeah, it's still not ended.
Okay.
It's in progress.
Okay.
Yeah.
And how long had this outage been planned for?
This outage window had been selected and planned at least a year in advance.
And what was the purpose of this outage?
The outage was a routine annual maintenance inspection outage. Has two primary purposes. One is to inspect the components of the engine and related support systems to determine if there are any issues developing that need to be addressed, repaired. The other would be to inspect the exhaust and the emissions control components to make sure that there was no wear or replacement or adjustment of any components, and that the physical condition of the equipment was satisfactory for continued operation.
During an outage like this, is the unit completely offline or can it operate?
No, during this outage and similar outages, the equipment is out of service. It's completely offline.
So turning to the sorts of tests that are conducted, can you describe the bore scope test that was performed on December 4th, which was 1 day into the outage?
Yes, bore scope inspection. A bore scope is a tiny camera that is attached to fine wire filament that can be inserted into the machine to allow a visual inspection of internal components that otherwise would be impossible to see without major disassembly efforts. So it's a very effective, well understood technique for internal inspection of equipment condition.
And so the test was conducted on December 4th. Do you know the date on which SCE received the report from that test?
Yes, the report was received on December 5th, 2019.
And what did the test reveal?
The test revealed the areas of impact damage that were illustrated in the photographs that were submitted earlier. So at that time, we understood for the first time there was internal damage within the engine.
And what were the significance of these results?
This was a significant finding for two reasons. One is, during the conduct of a bore scope inspection, you see what you can see, what you can access, and the areas that could be accessed were found to be damaged. We had concern that there may be other inaccessible areas that could have been damaged also that were not detectable through the bore scope inspection. And also the areas of damage that were discovered were of high concern to us because it's known that the damage, the type of damage that occurred could impact cooling flow within the components of the machine and potentially lead, if not corrected, could lead to further catastrophic damage if we had opted to return the unit to service without making repairs. It could have led to additional damage, perhaps even catastrophic damage as a result of that decision.
Were there safety concerns if the damage wasn't repaired immediately?
Yes, absolutely. Safety is our top corporate value, and it was driving the decision in this case. So from a safety perspective, we were concerned that additional damage that could occur as a result of not having made the repairs would likely have caused additional equipment damage and could have led to injury of personnel who happened to be working in the area should that have occurred following the return to service.
Okay, so just to confirm, SCE felt it was absolutely necessary to repair the damage immediately before trying to operate the unit again.
That's correct. Our Edison internal subject matter experts believe that it was necessary to make these repairs before returning the unit to service. We also consulted with the original equipment manufacturer, General Electric Company, and their subject matter experts recommended that the repairs be executed before returning the unit to service as well. So there was agreement between General Electric and Southern California Edison on the necessity and urgency of the repairs.
What's involved in repairs like this? Can someone just, kind of fix it on site, or does it have to be sent somewhere?
Unfortunately, the repairs are internal to the engine, and accessibility to the repair location in place is impossible or impractical at least, and the most expeditious path forward is to remove the engine from the machine and execute the repairs with the engine removed.
And is that, in fact, what the first photo in Exhibit 2 shows?
Yes, you can see the engine is suspended and it's in the process of being removed from the machine to allow for disassembly and access to the repair locations.
So at this point, what were you planning to do?
Our original intention was to utilize a spare engine that we had in our critical spares inventory and to simply remove the damaged engine and replace it with the spare and then return to service.
And why did you think that this was a viable option?
We had knowledge, myself personally and others at Edison, as well as some of our competitor generation companies. We had knowledge of this technique having been used successfully in other locations where damage had been discovered in the engine, and those facilities removed the damaged engine and replaced it with a backup, identical backup.
And so the intent was then that you could resume operations after the outage and then complete the source test that was scheduled on December 18th.
That's correct. Had we gone forward with the turbine swap or the engine swap approach, that would have taken just a few days to complete, and we would have had the spare engine in place and in service well in time to have conducted the follow-up source test.
Thank you. That's all I have. Mr. Maddox is now available for questions.
Thank you. Ms. Reichart, questions for Mr. Maddox?
Thank you. I just want to make sure, excuse me, that I understand the timing. When did you do the bore scope?
The bore scope was done on December 4th,
Okay,
one day into the scheduled outage.
one day into the scheduled maintenance. And then, since you'd been having problems with the engine, was this not, why hadn't you tried this technique earlier in the troubleshooting process to figure out what was going on?
So the types of problems we were experiencing were unrelated to physical condition of the internal of the engine. It's more emissions control equipment at the exhaust of the engine, so completely different scenario.
Okay. And then, have you been able to determine what caused the damage?
Yes, we believe that there are two areas where metal particles were liberated. One was on a stationary blade upstream of the damage area. The other was on a fuel gas injection nozzle where metal had broken free and become liberated and then traveled downstream and impacted the other area of damage. So we believe that's the cause of the discovered damage.
And is that something that's going to happen again, or why did those metal pieces come free?
Yeah, it's most likely a result of the thermal cycling as the unit is started up and shut down repeatedly over the course of the year. Being a peaking facility, it starts and stops sometimes 3 times a day. And that thermal expansion and contraction can lead to fatigue, thermal fatigue, and liberation of metal. That's one reason we do these annual outages and perform the bore scope inspections, is to look for evidence of that, and then when it occurs, to correct it.
Okay. So you'll be able to solve whatever problem was causing those metal pieces to come loose?
Well, we will be able to make repairs and to return to service with an intact, the integrity, the metallic integrity will be restored. But the cause of the damage is an outcome of the way the unit's operated, and that will always be a risk. And so we'll always have to make sure we schedule these outages and conduct our due diligence with inspections and repair efforts. It's the reason we have the outages. Otherwise, we just run without doing any type of inspection or repair. But we want to make sure we catch these and correct them before catastrophic damage occurs.
Okay, and then, so the When was the last time you had performed a borescope on this unit?
It would have been the prior year.
In December 2018?
Right.
And everything was intact at that point?
At that time, we did not discover any areas of damage.
Okay. And when did you first discover that you would not meet be able to make the December 18th scheduled test date?
Well, when we were pursuing the approach that involved swapping the engine with the spare, we believed that we could complete that and still complete the source testing successfully. It was only after we determined that that was not the approach we were going to take. We were instead going to have the damaged engine repaired and put it back in service, which takes much longer, weeks longer. At that point, we realized there was no way we could complete and return to service in time to do the
And what
testing.
date was that?
Let's see. It was around November 7th, if I recall correctly.
November? It was November.
Or, I mean, December.
Okay.
December 7th.
And when did you file the petition? Do you know?
Yeah, that was,
If you don't know, I can ask Mr.
yeah,
Scott.
go ahead.
Okay, so that would be another witness.
That's
Okay,
next witness, yeah.
okay, thank you. No
We,
further.
we,
oh,
we could just take, we have it date stamped, the petition was filed on, oh, you're talking about the petition,
No, this petition, for
Yes.
some reason, I don't have a date stamped copy. So then I
December,
was like,
December 17th.
thank you.
Okay, so if you had follow-up questions, it is, we'll take notice of the fact that it was
Okay, that's all, the only
filed,
thing I'm missing, so that's fine. I just.
that it was
I-
filed December 17th.
Yeah, I just realized I didn't have a date stamp copy, so I felt like I would just go ahead and elicit that in testimony. All right, thank you very much. No further questions of this witness.
Go ahead, Mr. Balagopalan and then Ms. Verdugo Peralta.
Mr. Maddox, you mentioned that you were monitoring the ammonia. Do you have a SEMS on the unit? How were you monitoring that there was excursions?
Yes, it does have an emissions reduction control system, a continuous emissions monitoring system, and we're able to monitor a variety of emissions components and trend them and detect if one is problematic, including NOx.
And if you were able to swap the engine out, you would have been able to test it. Did you resolve the issues with the excursions? And hypothetically, if you were able to swap it, you said you could have done it in time for the test, right?
We were optimistic that we could complete that in time to support the original test date. That's correct.
And had you by then identified what was causing the excursions, or?
We had a number of countermeasures that had been identified, most of which involved tuning constants in the control system that we would implement, which by themselves do not require an outage to implement. But the outage would give us an opportunity to see if there were any physical constraints, valve operation or valve wear, those sorts of things, the support equipment.
You also mentioned that it was your knowledge, or it was common knowledge in the industry, that replacements were routinely done. There were a number of facilities where that had occurred, or to your knowledge?
Yes, I'm personally familiar with facilities that have done that, and General Electric Company, this engine is called an LM6000, and there are thousands of these identical engines in use across the world, and a common technique is to have a backup spare LM6000 unit, and when the running unit is damaged, rather than repairing and returning that damaged unit to service, just remove it from the machine and utilize one of the identical spares and return to service quickly. That's very commonly done worldwide by the entire LM6000 fleet.
Did you cite, I believe you had discussions with the district staff on this issue, correct? And they notified you, according to the petition, December 13, that you may need a permit, is that your understanding?
That's my understanding. I was not personally involved in those discussions. The next witness was, but that's my understanding that that dialogue took place.
And you understand, you don't know what, if there was any rule that you could cite that would have allowed the practice of swapping? Were you aware of any rule in the district, any district regulation that would have allowed this swapping without getting a permit?
I think the best way I can answer that is I was not aware of a rule that would have prohibited it.
Okay. All right, thank you.
Can I just, and then I'm going to turn to Ms. Verdugo Peralta, but just on those questions, was it the intention to swap it simply for the source test and then to go back to the original engine? Or was the intention to swap it and use the spare engine here forward?
Yes, our intention was to do the swap, the engine swap, return the unit to service and run it long-term with the replaced engine. And then take the damaged engine that had been removed and repair it to create a new spare.
Okay, thank you. Ms. Verdugo Peralta, you had other questions.
Thank you, Madam Chair. Mr. Maddox, you mentioned the intermittent operation of the SCR that was sometimes on, sometimes off. How many times did that happen?
I don't recall exactly how many times the cycling occurred. We have that data, I just don't have it available right now.
Okay. And also, when you contacted the OEM, GE, who or how, when was that? What was the date?
We are in constant communication with General Electric and Company on issues related to the operation of the unit. So to find a specific date that we first talked to them about this issue, I don't recall exactly when that would have been.
You don't
Probably,
recall?
it certainly would have been early in 2019. Those
Okay.
discussions started immediately as soon as we had encountered the problem.
As soon as you had the first failure?
Yes.
Okay. And I'm looking at the document on item number 14. Kind of think it's.
We're looking at the
The
petition.
petition on number 14. It's kind of the same question, but let's see here. On the modification, when did you first contact South Coast AQMD to have that discussion with them?
To me, you mean the discussion of swapping the two
Whatever
engines?
whether the repair was going to be done or whether it was going to be just a swap. Do you recall?
Yeah, again, I was not personally involved in that conversation, so I defer to the next witness to provide that exact date.
And
Okay.
we can hold that question for the next witness.
And then my last question is, as you mentioned, you were going to replace this particular engine long-term and repair the other one for the spare. Now, is the one that you were going to replace it with, is that more efficient as far as controlling the NOx than the one that you're going to repair?
The engine units are identical, so the ability to control NOx would not have been impacted by the engine swap. That was downstream components on the exhaust of the engine. But the engine itself, they're as identical as anything gets. Every LM6000 is exactly the same.
Thank you.
Just one question on that. I don't want to get too much into it, but you say they're identical, but there was an upgrade to the engine that exists right now, including catalyst replacement. The spare engine, is the catalyst, is that included in the engine or that?
No,
No,
they're
okay, so that's a
separate.
different part.
Yeah,
Okay.
the engine, the combustion and the rotational energies introduced in the engine.
It's just separate.
Yes, it's separate. And then downstream of the engine, at the exhaust of the engine, are the NOx control components. So swapping the engines out would not affect
Not affect that.
right.
Thank you.
You're welcome.
That's clear enough. I had a few clarification questions. First of all, you were not sure how long the planned maintenance was supposed to be, and in the petition, it says the dates of December 3rd through the 12th. Does that seem correct to you?
That was correct going in, yeah, with what we knew.
The original.
The
is what-
original.
Okay.
yeah.
And then I wanted to understand if you could just elaborate a little bit. So on the November 14th original scheduled date, you had those difficulties that you've been having intermittently throughout the year, correct?
Correct.
Okay. So why were you optimistic, having had this issue throughout the year, that by December 18th it would be fixed? If you could just elaborate a little bit.
Yeah, we had some subject matter experts that were engaged and had developed some countermeasures that involved revised testing or tuning constants in the control system that we believe would have allowed us to achieve the ability to successfully complete the test in full automatic with the application of that last batch of corrections.
And in the past, during the year 2019, when you've had these intermittent issues, have they been resolved within that time frame of November 14th through December 18th, within a month or so?
We saw evidence of improvement from time to time, and then because of the intermittent nature of the problem, sometimes we were misled. I made assumptions that we had solved the problem effectively and with finality, and then time would pass, we'd operate again, and the problem would recur, and we realized we hadn't fully solved it yet. So to say that we had completely solved it each time, that's certainly not the case. I think we made improvements and progress each time, but we just weren't 100% done yet.
Okay, but just to be very clear, your answer to Ms. Reichardt's question was that that intermittent problem you have been experiencing with NOx exceedance is not the same issue you're now facing with the engine and the actual damage and the need to replace it before the source test. Is that correct?
That's correct. They're very different issues. One is component damage, and the other is the ability to control NOx, and they're separate issues, except that one depends upon the other.
But you would not have known about that damage that we're now looking at, the damage that you showed us in Exhibit 2 in the photographs. You would not have known about that except during that December 3rd to 12th timeframe when you did the borescope test. Is that correct?
That is correct. Prior to the outage inspection, we had no reason to believe that we would discover internal damage. Most of the borescope inspections that we do reveal that all is well, that there's inconsequential damage. This was an exception to that pattern.
Thank you. And then the next witness that we're going to have is going to better explain what occurred between December 5th or 4th, when the damage was determined, and December 13th, correct, when the determination was made that you couldn't swap them out to do the test.
Yes, he will explain the circumstances for the reason that Plan A was abandoned, the engine swap approach was abandoned.
Okay, thank you. And then my final question has to do with, we have the fourth finding that we need to make, which is that there is that a denial of an interim variance first hearing, and then the variance itself would result in an unreasonable and unavoidable adverse impact to petitioners. So you are not in violation of any rule or permit condition until the 31st of December, is that correct?
That's my understanding, yes.
Okay, so we're looking at the time frame between then and when a noticed hearing could be heard. So my first question is, do you know why there was a continuance that was requested from the 7th, when this case could have been heard on a short variance, to the 14th?
I'm going to defer to the next witness to answer that more fully than I'm prepared to answer it.
Okay. The other question is, do you know, or should we defer to the next witness for this also? Other than potential penalties for being in violation of the requirement to have that source test done by this December 31st, do you know of any other harm that would occur if we were to wait for a noticed hearing?
Well, we take very highly the ability to meet all of our environmental regulations. And Southern California Edison would prefer not to risk an environmental violation.
Okay, so but other than penalties which would assess, and we appreciate, of course, the board that you're here asking for relief and doing it the correct way. But other than penalties, are you aware of any other financial, or, let me ask it this way, if you miss a source test, are you permanently unable to use that piece of equipment, or is it just penalties that would assess until you can actually complete the source test? Is there anything else like that that you would undergo?
Nothing that I'm aware of other than the financial penalty and the reputational damage.
Thank you very much. Any other questions? Ms. Verdugo Peralta, and then I don't know if other.
Thank you, Madam Chair. Mr. Maddox, how old is that original engine that failed?
Let me see if I can recall the date that it went into operation. I'm going to say it's approximately 9 years old.
And the life is normally?
Many years. These devices can last for many years, 20, 30 years, depending on the way they're operated. The way this machine is operated is problematic in the sense that we would expect the life to be less than 30 years. It's not a base load machine. It cycles frequently, and that is strenuous. It can do damage, and so that's why we have to conduct these regular inspections and maintenance outages to detect that and correct it. But it was well within its expected lifetime.
And my other question is, coming from the utility industry, I know what the black start process is and how critical it is, but can you explain that to the rest of the colleagues here?
Yes, black start machine is one that is not dependent on a source of external power to run the auxiliaries that are required to return a unit to service. It's self-sufficient. So in our case, we have on-site a couple of natural gas-fired emergency generators that can supply power to the auxiliary equipment so that this plant can start up if there's no power available externally. So in the case of a region-wide blackout, this plant can start up and re-energize the distribution system and allow us to put the grid back together from a blackout condition. Most plants require an external source of power to run auxiliary pumps and motors and such to allow you to restart the unit. And this one has the capability to restart without that external support.
And how critical is that to the state plan, CAISO, so forth?
It is extremely critical to the reliability of the grid in Southern California, and it is the primary reason that Edison was mandated to construct the facility in the first place, was to provide black start capability. It's the reason Barry Peaker was built.
Thank you.
Okay, Miss, sorry.
You get a chance at all over there?
Oh, yeah, you didn't indicate you wanted to. Senator has a question.
You just look over there all the time, that's why I was asking.
I looked both ways. I
No,
didn't have an
no, no.
indication.
You name them in advance before they make the request.
Okay, that isn't true, but I'm not going to
Thank
argue
you
with
very much. You don't have to argue, that's clear. The record shows that. My question to you, sir, is that in the petition, he clearly states that it's standard practice and procedure by the industry to provide for the swap. Is that correct?
That was my understanding, that it was common industry practice to utilize that as a strategy for recovery.
And so what we're trying to determine is what do you know, when did you know, and what rule have you violated before we can proceed? Mm-hmm. And you, in discussing the operation of the system, you introduce a lot of dates, events occurring at certain dates, and I'm just trying to get them organized in my mind so it enable me to make the right decision according to the evidence. When did you discover, or when were you informed by the district that you could not make the swap?
Yeah, it was the following week that I became aware that the
Following the week, what do you mean, what week?
the following, the second week of December. So we had the discovery of the damage during the first week of December, and anticipated during that week that we would be allowed to do the engine swap technique. And all of our plans and preparations were assuming that that was the route we were going to go. Plan A was the engine swap route. And out of an abundance of caution and respect for the district, we contacted and asked the question if that was an allowed approach. And those discussions took several days to get resolved. And I became aware the following week that we were not going to pursue Plan A, that had been determined to not be a viable solution for us. And so we would have to take a different approach, Plan B, that involves sending the damaged rotor to a facility in Bakersfield, California for repair and return, and that would take many more weeks. It would anticipate being done in the middle of January. And so by the second week of December, early in the second week of December, I became aware that we had a timing issue with regard to satisfaction of the permit requirement.
I think your initial statement was that you're the manager of maintenance and maintaining the equipment?
Yes, we have a team.
You are in charge.
I'm responsible for that fleet, yes.
Right, and therefore, you thought that you would comply with this industry standard by making a swap, is that correct?
That's correct, yes.
Okay, and until what time did you discover you could not make this swap?
Yeah, I'm trying to remember the exact day that notification came back. It was the following week, the week of December 9th.
And Mr. Mannix, you had said that the next witness could be more precise?
Yes, the next witness actually had the direct discussions.
Everybody can have their own right to ask questions. If another witness is to answer the question, he will so state. We did not. You asked him.
Okay, we both myself and other members had asked that question, and he had deferred. But you can ask whatever you want, Senator. I'm not
Please, I'm
stopping.
glad you permit me to do so. Now, the permit manager, was he the one or AQMD inform you that you have to?
Well, again, sir, I did not have those discussions personally. That was the next witness who had the discussions with SCA QMD. And so as that individual returned with feedback from the district, then we acted on it accordingly. And so after those discussions took place, we were notified, we being the operations arm, were notified of the outcome, and we adjusted our plans accordingly.
Well, you had a series of problems associated with this engine. To your knowledge, when did it first start, the problems?
Well, in terms of the problems with the engine itself, we were unaware that we had problems with the engine component itself. What we knew we had problems with all year was the ability to reduce the NOx emissions produced on the exhaust of the engine.
What are the failures if you're unable to start up the engine? What seems to be the failure, maintenance-wise?
Well, if we had opted to continue operation with the damaged engine, there was a high level of concern that additional damage would occur that could have catastrophic consequences that would further damage the engine or even potentially injure our personnel who would be working in the vicinity.
The permit to operate is located at the site that it's operating, is that correct?
I'm sorry?
The permit to operate equipment is located at the site where it's located, is that correct?
That's correct.
Do you ever
yeah.
refer to the permit to operate?
Yes,
When there's a problem, you look at the permit to operate,
yes.
and you determine whether or not they're violating any rules or that permit?
Yes, we, upon inspection of the permit, that caused us to have concern that generated the additional conversation with the district.
I'm asking these questions, I'm going to get the timeline, if I'm permitted to do so. And on November 3rd, I'm sorry, November the 19th, 2018, you received a notice of violation. You had a problem then, is that correct?
Yeah, I don't,
That's the NOV.
Let's refer to that. It's attached to the petition, and the date, there's two dates. The date of violation is, in fact, the November 19th, 2018. The date of the actual notice is in the bottom, and it is October of 2019. And if Mr. Mannix, if you can.
That's what I'm trying to get to.
Yeah. I'm just clarifying for the record.
Well, the record shows that.
yes, that, I do see that, and that is, that notice of violation is related to another parameter of operation. It's not the one that's the subject of today's hearing.
It's a startup complaint. Failed to start up. Did you read it?
Yes, I'll read it. It says, failure to comply with the startup hour CO emissions limit of 8.74 pounds. So this is, this notice of violation is for a matter unrelated to the subject we're discussing today.
But it suggests that you should, in any case, that you're having problems with the engine and you were not in compliance with the permitted condition. Is that correct?
It indicates that we had a problem with the emissions controls equipment at the exhaust of the unit. It did not imply to any of our subject matter experts, internal or external, that there was physical damage to the internal components of the engine.
May I just ask also, the date of violation is in November of 2018. The upgrades to the engine were done or to this unit, were done in December of 2018 afterwards? I just want to make sure we understand the
That is correct in terms of sequencing. So the upgrades that I mentioned with regard to the NOx removal catalyst, or the removal catalyst, that work was completed in December 2018, which would have been after this event.
So your original schedule for inspection or whatever was November 2019, is that correct?
December 2019, yes.
No, the original schedule was November. You got to reschedule because you were not being compliant in November.
Yeah, the original testing
Yeah.
was scheduled for November 14th. That's correct, sir.
Right, 2019, okay. And so you rescheduled to December 18,
Correct.
okay, and you discovered that you were not ready for December 18th because of these problems that you've discussed.
Right. Because of the damage that we discovered and the technique to restore operation following the discovery of that damage and the timing of it, we realized we would not be able to meet the revised testing date.
All right, thank you, sir.
You're welcome.
Are there additional questions for Mr. Mannix? Mr. Balagopalan?
Mr. Maddox, typically when do the pickup line is called into service? In the winter months, or let me rephrase that, in the winter months, are they called into service?
I'm sorry, I don't.
The pickup line is on demand when there's
Yes. In most cases, the peaker plant is can be awarded a day-ahead award. If the California Independent System Operator, the CAISO, determines that there's a capacity and shortfall or a constraint in the network that requires relief, they can award operation of the unit next day. Or in other cases, the notice is short-term. There are unanticipated flow constraints or capacity limitations, and we may get a very short notice startup that as short as 10 minutes notice. So it depends on the topography of the electric grid and the conditions that are known and projected for following day. And they don't always capture anything that might happen with regard to an unanticipated derate or trip of another unit that might require replacement capacity on short notice.
So it's not a seasonal, you cannot say, there's less demand during the winter months versus summer months?
Traditionally, peaker operation occurred during the summer, what was called the summer peak load period, but over the last few years, the last couple of years, maybe even the last 3 years, the concept of peak load being associated with summer operations is no longer valid. Peak load conditions can come and go at any time of the year now. It's no longer seasonal as it once was.
Okay, thank you.
Senator?
Again, December 9th, 2019. There's a second stage and blades were discovered that was a problem. Have you explained that yet so far?
Yes, we found that as a result of the bore scope inspection that took place, some unanticipated internal physical damage was discovered.
Okay, when you did your upgrade in December 2018, it was completed. Did that include the problem associated with NOV, which was discovered 11 November 19, 2018? That upgrade, would that fix that problem as well?
It could have helped correct the problem, yes, even though that was not its primary purpose, but it would have been beneficial to that.
Okay. Yeah. Once again, thank you.
Yeah.
Any other questions for Mr. Mannix? Okay, thank you, Mr. Mannix.
May-
And- Oh, did
Sorry.
you have?
I had a few clarifying
Yes,
questions. if you don't
please.
mind. Yes, okay, I'll make this very brief. Returning to the variance petition, looking at our response to question number 14. And let me turn to that page for you. Here you go, it's page 4 of 9 on the petition. If you look at our response to question 14, you testified that the bore scope test occurred on December 4th, and then SCE received the report from that test on December 5th. Is that correct?
That's correct.
But in the answer, we say we were undergoing the scheduled maintenance activities on December 9th when the damage was discovered. So should the reference to December 9th be removed and be replaced with December 4th and 5th?
Yes, it should.
Okay.
That needs to be corrected.
Okay, great. So we'd like to note that.
It is so noted.
Okay, great, thank you. And then I just also wanted to clarify a prior answer that you gave, and it's related to that. As of December 5th, you were planning to proceed with the engine swap.
That's correct.
Okay. And then our next witness will describe discussions that were held with the district and when those occurred. And finally, I just wanted to make a final clarifying point. We've been talking about two separate problems here, and it does get very confusing with all of the various dates, and we apologize for that. But there are two separate problems. One is the damage to the engine that was found in the bore scope test, and the second is the SCR problems. Now, and just to help everyone understand, is it true that really the only significance here of the damage to the engine that was found during the outage is that it rendered the unit out of service, and therefore we will not be able to make the rescheduled December 18th, 2019 source test?
That's correct because of the decision to repair the damaged engine and return it to service rather than executing a swap.
Okay, but other than that, there is really no connection between the damage to that was found to the turbine rotor blade and the SCR issues that are ongoing?
That's correct.
Okay, Thank you. I have no further questions.
Senator had a follow-up.
Right, on that subject, up until December 12th, 2019, it's written in your petition that it was the anticipating that the district staff would approve the turbine swap, right?
Correct.
That's what you wrote. And it was that date, that's very significant as the action that we will take, that you discovered they require a permit modification, which would require this action that we're taking today. So, all right, so I want that clarified. That's good.
Yeah, the sequence was such that going in, we had every anticipation that the engine swap would occur, and the timing of the follow-up test would not be an issue. Once that was determined not to be true, then we had to adjust to a different repair evolution that would require much longer. At that point, we realized we had a timing problem with the test. And the specifics about who said what when, I'll have to defer to the next witness for that, to tie down the exact time those conversations took place. I only know the sequencing and when I was informed, but I'll let the next witness answer detailed questions about the timing of those discussions with the district.
Thank you. If there's no other questions for Mr. Mannix, then we're going to take a 15-minute break, and we will come back with your second witness. So let's take a 15-minute break, and we will come back at 10:35. We are off the record. Okay, we are back on the record, and we were going to begin with your second witness, Ms. Henderson.
Yes, thank you very much. I have here Casey Scott of Southern California Edison. Could you please state and spell your name?
Sure. Yeah, my name is Casey Scott. That is CASEYSCOTT.
Are you testifying under oath today?
Yes.
What is your current position with SCE?
I'm a senior advisor in the air quality group.
And what are your job responsibilities?
So I'm the program manager for our major sources, which are Title V facilities. And so I'm in charge of dealing with any air quality issues that come up with those facilities. And that includes the subject facility of today, which is Berry Peaker.
And your job responsibilities include communicating with the district about the interpretation of permit conditions?
Correct.
Okay. Did you contact the district to discuss SCE's proposal to swap out the damaged engine with a spare unit?
Yes, I did. And the first contact I made was on Monday, December 9th, via email to our permit engineer. And that was the first time it came to my attention, or our group's attention. And as the district is off on Mondays, I started out with an email correspondence on the 9th, and then followed up the next day with a phone call.
And what were you expecting the district to say?
So hearing about the issue from Terry's group, Mr. Maddox's group, we believe that this would qualify for the exemption in Rule 3000B17A, which is for routine maintenance and repair. And that would be an exemption from going through with a new permit application for a modification. And this was regarding the swap. So we believe that that swap would qualify under that exemption, and we would not have to go through the process of getting a permit. And you know, everything we'd heard from GE was that, you know, this was, as Mr. Maddox stated, this was standard maintenance and repair, and they'd done this with other clients, and they even classified in their documents as level 1 maintenance. So our expectation was the district would agree with this interpretation, and we mainly reached out to them out of an abundance of caution, and we just wanted to get confirmation of their interpretation on this, and so that's what we were expecting.
And so when did you first discuss this with someone from the district in person? What was the date?
So that was Tuesday, December 10th, and those discussions continued throughout the week. Again, we kind of expected a quick response on this based on the information we had. We kind of, you know, expected it would be a quick confirmation on their end. It quickly turned into a bigger issue. We had back and forth discussions over the next few days. So the first email that I sent was on Monday, December 9th, and then we started discussing in person over the phone on December 10th, the next day. And so that was on a Tuesday, and throughout the rest of that week, we continued to have discussions on the matter. And it finally became clear at the end of that week, so that was the morning of Friday, December 13th, that it became kind of clear to us that the district had done their own research on this, and they did not agree with that interpretation that swapping the turbine was going to be routine maintenance and repair. And if we were going to go through with that approach, we were going to need to do a permit application. So if we wanted to get the turbine back in service quicker than that, we were going to have to start exploring other options, with namely taking the existing damaged turbine off-site for repairs.
And what implications did that have for the source test that was then currently scheduled for December 18th?
All right. So as Mr. Maddox stated, taking the turbine off-site for repairs was going to be much more time-consuming due to the extent of the damage. And so the initial estimates we got from GE were that it would be available back sometime in mid-January. So obviously this meant we would not have the turbine ready for the December 18th test or for meeting the quarterly deadline of December 31st.
And so then what did you do in regards to the December 18th test?
So we immediately had to cancel that test, and we reached out to our vendor to look at rescheduling that sometime in January. And we currently have that rescheduled for January 28th, assuming that the turbine is back and repaired at that time.
So you testified you got the definitive answer from the district, no, this is not routine maintenance, on Friday, December 13th. When did SCE file its variance application in this matter?
So yeah, the morning of Friday, December 13th, we kind of came to that conclusion that we were going to have to pursue an alternate avenue to get the turbine repaired. We had a conference call that afternoon to discuss what we were going to do, and at that time, we decided to send the existing turbine off for repairs. We knew that was going to take until mid-January, so we immediately started working on a petition for this variance. And the next available date to file would have been December 17th, the following Tuesday, which is what we did.
And what was the date that the hearing board scheduled the interim hearing?
Today, which is December 26th.
Okay. Why can't SCE wait the required notice period for a short variance?
So unfortunately, because we're going to be out of compliance starting on January 1st, as we mentioned, this is a quarterly test. It has a December 31st deadline. Unfortunately, that did not allow us enough time to wait the 15 days for the public notice period before we're out of compliance.
And I now make Mr. Scott available for questions from anyone.
Thank you. Ms. Reichart, your questions?
Thank you. I believe the board asked this of the previous witness. Can you discuss the reasons, if you know them, as to why the short variance hearing was rescheduled from, or requested to be rescheduled from the 7th to the 14th?
I believe that's because of our attorney's availability. I'll let her comment on that.
Would you like, do you want me to talk about
do
that
you
now,
wanna-
or I can explain that later. That's completely my fault. I have to go out of town on.
Well, since I had those questions, we might as well have
Okay.
you answer now. That would
Yeah.
be fine.
When I originally, I spoke to the clerk to schedule the hearings on the 26th, and for the short hearing date, she had said the 7th and the 14th were available, so I took the 7th. And then I subsequently found out that for family reasons, I need to visit an elderly relative out of state, and my husband booked the flight for the morning of January 7th, which I did not realize. And so I called back and said, do you have any other availability? And they said the 14th was the first available, so it's
Thank you.
purely based on my own issue.
Thank you very much. Did you have any additional
No
questions?
other questions, thank you.
Okay. Senator, did you have questions?
Mr. Scott, how are you?
Well, how are you?
All right. You had a discussion with the district regarding the timeline, is that correct?
Yes.
And whether or not routine maintenance was insufficient to correct the problem.
That was the ultimate conclusion from the district's end, yes, regarding the turbine swap.
What was your expectation prior to that discussion?
That was a surprise. Prior to that, as Mr. Maddox went through, this is considered, routine maintenance and repair by the industry. This practice is pretty standard, so that was kind of our mindset going in, that we would get approval from the district. So, yeah, that ultimate ruling ended up surprising us.
Previously, have you had a problem associated with this engine prior years? It's been in operation for many years. Do you know, how long have you worked for the company?
I've been with Edison since 2013. That's 6.5 years.
Okay. Have you had this kind of problem before with this engine?
Not this particular problem. We've obviously had, maintenance issues over the years that have been corrected during outages, but the extent of this repair, I do not believe so.
Do you have any reference previously of any condition similar to the one we face today?
Not personally, no. I'm not privy to everything that goes on at the sites. Like I said, I'm in the air quality group. I manage all the sites, so that level of detail, I would probably want to defer to people on site.
How many engines like this operate at these various sites that you know of?
We have 5 of these peakers. 4 of them are on the South Coast.
And this is the first time you had this kind of a problem with any of them?
Yes, I believe so.
The problems you've had before, did the district permit you to continue your ordinary maintenance program?
For the type of maintenance we've had to go through that hasn't been to this extent, yes.
They never requested on any of those other engines that you go through permit modification?
Correct.
Thank you.
Yep.
Ms. Verdugo Peralta first.
Thank you, Madam Chair. Mr. Scott, are you the subject matter expert for this area on air quality?
Yes.
And so you were the subject matter expert on this particular project?
Well, I'll caveat that with saying Mr. Maddox had referred to subject matter experts a number of times in his testimony. That referred to more the technical aspects of the turbine, more sort of the air quality permitting subject matter expert.
And you didn't bring any of your subject matter experts with you today?
No.
My other question was, it's mentioned over and over that it's common practice to swap out these engines. Has that occurred within the South Coast territory, that you have done this with other engines?
Not Southern California Edison personally, but we have heard about other utilities that have done this in the South Coast.
Within South Coast?
Yes.
But you don't have that information specifically?
I'm not at liberty to share that.
That another utility has done that?
Correct.
Interesting. Thank you.
Okay, so we've heard that NRG has done this particular swap before with only follow-up implications from the district.
Do you know how long ago that was?
I believe it was a few years ago.
Thank you.
Mr. Balagopalan had a question.
Yes, Mr. Scott, you mentioned Rule 3000B17A in your discussion with the district to see whether it qualified under that and would be allowed the exemption to. Did at any point did Rule 219C3 come into discussion?
Yes, and that ended up not applying in this case because we were subject to, I believe it's Quad K of the NSPS, and that particular, because we're subject to that particular rule, that negates that Rule 219 exemption. But we did discuss that with the district, yes.
Oh, I see. Okay, thank you.
I just had one question, and that is, if an interim variance were denied today, I know there was testimony regarding the fact that running the engine as it currently is could create more damage to the engine and could create a safety hazard. Is that correct?
Correct. Yes.
But could it be run, could it physically be run and the testing done?
I believe so. Not knowing the intricate details, I believe it could be run.
Okay.
Yes.
I wanted to know the answer to that. Thank you. Anyone else have any further questions? Dr. Bernstein and then the senator.
Mr. Scott, I've always wanted to say that. However, it is a safety issue with regards to running that equipment, given the testimony that's been placed before us today, correct?
Correct.
And I'm sure that Southern Cal Edison would rather not run that piece of equipment, given the safety hazard that could, and what could possibly result as a failure of that equipment. Is that correct?
That's correct.
Okay, thank you very much. Would you beam me up, Scotty? No. Forgive me, everyone. It's a holiday spirit.
Senator has a question.
Mr. Scott, who did you talk to in your district regarding the request for permit modification?
So my initial contact was with Chris Perry, our permit engineer, and then later on that got escalated to his permit manager, which is Bhaskar Shandon, and we also had phone calls with him.
And he said you need a permit to modify the equipment, correct?
Yeah, ultimately, like I said, on Friday, December 13th was kind of when we got that solid ruling.
Did you share with him your previous experience and the experience in the industry that the swap was permitted?
We did.
What was his answer to that?
He listened and took that into account, but they needed to do their own internal research on the matter, which is what they did.
They did.
They considered that.
They had their own research.
Yeah. Yes.
And they give you any report or any technical data regarding their research?
We do have some documents that they sent us over, mostly dealing with how other agencies have dealt with this matter. And so that was what's helped inform their conclusion that this would not qualify for routine maintenance.
So other agencies, how did they deal with this matter?
A number of agencies deal with it in a number of different ways. I can mention one in particular, if you'd like to hear that.
Please.
Yes. So Bay Area Air Quality Management District, they require a particular permit condition that's added to the permit that allows for this type of swap, provided that other notifications are made to the district, such as, when this is taking place, the new serial numbers that would be involved, and some other small notifications that would be made. But there's a permit condition added that would allow this.
Is that considered a permit modification?
Because it's in the permit already, a separate application would not be needed, as long as you notify the district. That's how.
So therefore, the industry standard does vary from time to time, is that correct?
It appears to be.
According to their report.
According to this report, yes. And this, we were told this happened just this year, that they came up with this solution. Bay Area did, so fairly
This
recent
year, okay.
development. Yeah.
Right. Which you were not aware of.
Which, correct, we were not aware of.
Any other questions for Mr. Scott? Mr. Balagopalan?
Mr. Scott, can you, what is Quad K? What's that
It is for
referring
gas
to?
turbines, and it's, there's an interaction with that in subpart quad G, or sorry, just GG, and that's based on when the turbine goes into operation. So I think it's 2005 is the cutoff.
So
So it's for gas turbines.
and the facility is subject to that? The new, okay, thank you.
Okay, any other questions on good cause? Okay, thank you, Mr. Scott.
you.
Any other witnesses for good cause, Ms. Henderson?
No,
Okay.
we're done. Thank you.
Ms. Reichart, did you wish to have any witnesses on good cause?
No witnesses.
Okay. I want to ask for public comment since there is no public. Ms. Henderson, any closing you'd like to make on good cause before we deliberate?
Yes, I'd just like to briefly address the 4 elements that are required. The first being that there was no way for us to have a noticed hearing, and that is, we will be in violation of our permit conditions on January 1st, because even if we wanted to run the test now, we couldn't because the engine is in Bakersfield, and we wouldn't be able to run the test on the spare because of what the guidances the district has given us, that we would need to submit a permit application before we would be able to operate that. So there is really, we will absolutely be in violation on January 1st if we do not get interim relief today. On the second, that this issue reasonably could have been avoided or anticipated in sufficient time. And as you stated, that relates to not having the time to allow the 21 days for the hearing before the short variance. And for that, I'll say that we heard definitively from the district on December 13th that a variance petition was going to be necessary. And we worked on one immediately and had it filed at the next possible opportunity, which was Tuesday, December 17th. And the hearing date that we were given of today was 14 days later, which is 14 or 15, depending on how you count, on December, from then until the date that we would be in violation, which is the date of the expiration of the date of the deadline for the permit, which was December 31st. And then in terms of diligence, as I just explained, we contacted the district, our air quality staff contacted the district once they were aware of what the plan was internally, out of an abundance of caution, which I'm very glad that we did. As it turns out, what everyone had thought was, oh, no big deal, sure, this will be fine. It turns out to have been a very big deal, so I'm very glad that we tend to be conservative on these matters. And again, we filed the application as soon as we reasonably could after we had a final answer. And in terms of the unavoidable adverse impact, the fine is really not the issue here. It's just, we just do not want to be in violation of our permit.
Thank you very much.
Thank you.
Ms. Reichart, any closing?
Just the district is not opposed to a finding of good cause. Thank you.
Thank you. Board members, would anyone like to begin the discussion on good cause? And if not, I can start us off. I believe that we can make the findings for good cause. I do, again, there is no violation currently. There is no violation until the 1st of January. However, the violation will be imminent as of January 1st, 2020, and that is because ultimately they could not swap out the engine without a permit modification. That's not going to, no modification will occur and be completed by January 1st for testing, and the anticipated repair will not take place before January 1st of 2020, and in fact, as we just heard, the engine is not even on site currently. I believe that the circumstances that led to the violation could not reasonably have been avoided or anticipated in sufficient time for public notice. Again, we did hear a lot of testimony with regard to issues with the SCR and intermittent NOx exceedances and issues throughout 2019, but we also heard that that is not related to the current issue that makes the petitioner unable, or renders the petitioner unable to do the source test. That is a different issue, which was not something that could have been anticipated until the borescope test that was done on the 4th and the results received on the 5th of December, which show the damage that we see in exhibit number 2, those pictures, and had a safety issue, and so required taking it out of service. So I don't think it could have been avoided. However, I also don't think it could have been anticipated in sufficient time for public notice, because I think, and this is going to also play into the diligence, I do think that it was reasonable based on the testimony we heard today. They did a lot of research into whether or not they could do this swap. I think they had a reasonable basis based on 2 potential rules, which turned out not to be applicable for different reasons, but at least there was a reasonable basis on which they thought they could do this swap. They believed it to be routine, something that was done in different air districts, that was an industry standard. It just later on December 13th, they found that that was not going to be acceptable to the district and that a modification would be required. And then on the 13th, they would not have had a noticed hearing by the 1st of January, because we know a noticed hearing, even for a short, takes 21 days. And so they would not have been able to have had a noticed hearing by now. And I think they were diligent. Again, in the closing, we heard from Ms. Henderson that it was the 13th. We heard that in testimony, which they finally determined that a variance would be needed. That was a Friday. And then, of course, the district is closed until Tuesday, the 17th, and that was when the filing occurred, and so I believe they were diligent. The 4th is the hardest, but I think we can make that finding, and that is that there is an unreasonable and unavoidable adverse impact to petitioner, or that there could be an adverse impact to public health or welfare. I asked the question as to whether or not this engine could be put into service only for testing. The answer is yes, but of course we know that there is a safety hazard with that. So if we denied an interim variance today, which we haven't gotten to that part, but if we did, and they had to then put it into, 2 things would happen. Either one, they put it into service and they do the test. However, then the problem is there's safety issues, there could be further damage. That doesn't seem reasonable. If they don't, then they're subject to fines, and also, as they said, they want to be in compliance, and they would be not in compliance and in violation. But there are financial impacts and penalties, and when we're talking about an engine that isn't even operating right now, that seems unreasonable based on the fact that there's 0 impact. So those are my thoughts, and I'd like to hear if anyone else has any additional thoughts on the findings. Ms. Verdugo-Peralta, if you were.
Thank you, Madam Chair. For the reasons that you mentioned, I agree that we can find good cause. My biggest concern there is the safety to the personnel, and as well as possibly even the public. But I would really have liked to have heard from the subject matter expert for this particular project. I had a lot of questions that I would have liked to ask that were specific to conversations, as well as I would have liked to have heard from Mr. Shandon. But they're both not here, so I couldn't ask those questions. But in any case, because of the severity of the issue that they are also part of the Black Start program with CalISO. It's vital that this particular facility be online and to get the service back online. I still don't understand exactly why they couldn't swap out. I would like to know more about that, what our regulation says specific, and I think I would have been able to get that out of Mr. Shandon. But be that as it may, I do find good cause. Thank you.
And thank you. And I do think it's important to just point out for the record that what they're requesting a variance from, which we're going to get to in the merits when we get there, if we get there, is simply they are not able to test because the engine is currently out of service. So the reasons why the district is not allowing it, they're relevant, and it's mostly relevant, I think as the senator was pointing out, relevant to the timeline of whether the petitioner was diligent in filing and did they have a reasonable basis. But the district has said it's not going to happen. So the petitioner is still in the same quandary regardless of what those reasons are, because they don't have a working engine and they can't swap it out. So I think it's related, but I think we can move forward without knowing that.
But my concern is that if there was already a facility that they did allow that, I would like to know what the difference was. Did that set a precedence? Does this set a precedence specifically on that regulation? And why there was a difference? I would have liked to have known that. Thank you.
Thank you. Anyone else wish to have any thoughts? Senator?
Yeah, we can find good cause to hear this matter. Edison was not notified until the district informed them that they could not swap the engine. And that was doing a routine maintenance part of the program that they have in place. They discovered that there were some damaged parts within the engine. At that time, they wanted to replace the engine, and they could not do so. So then on December 13th, which was a short time, it became clear to me that they were very responsive when they discovered that the district informed them that they have to get a permit modification, and it would take a lot of time for that. They noted here in the petition. They said, yes, we'll repair it. It's not causing any harm to the public because the engine is not operating at this time. It will not be operating until they can pass the test. So I think they've been due diligent, and when they were informed, they responded post haste and filed a petition for modification, and they meet those standards.
Thank you. Mr. Balagopalan?
I also agree. I think we can find good cause. It appeared, during the irregular scheduled maintenance is when they discovered the damage to the blades, and so they prudently took it out of service so that it won't cause any kind of catastrophic accident at the facility. So there was, and I think the assumption that they could swap it up, being somewhat of an industry standard, I think is something that they knew that was been done, and so I don't think that was the assumption they went under was valid until they were informed otherwise. And I think we see also in the petition, the district hasn't actually finally ruled on it. It says it's not a final determination, but it's very likely it would trigger permit modification. So they may be still at, we don't know how it's going to be finally decided if they're going to allow it. But as the senator said, they're not in operation. There's no emission, so there's no impact to the public.
Thank you. I'm going to make a motion, if no one else has any other to add. In the matter of Southern California Edison, Barry Peaker, case number 1262-112, I move that we find good cause to proceed to a hearing on the merits in absence of notice to the public for the reasons that we just discussed. Is there a second? I did hear Dr. Bernstein first, so Dr. Bernstein seconds. Is there any discussion on that motion? Ms. Verdugo-Peralta, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
Senator, how do you vote? Dr. Bernstein, you vote?
Aye.
I vote yes. Motion passes 5-0. So we're going to move on to the merits. Now, I don't know if there's anything additional. I was just looking again at the 6 findings, and I'm not sure if we need any additional evidence. But what we'll do first and foremost is to incorporate all of the evidence we just received during the good cause portion, unless there's any objection. So, Ms. Henderson, do you have any objection to that?
No, thank you.
Ms. Reichard, any objection?
No objection.
Okay, so the evidence that we just received in testimony is hereby incorporated. And then I'm going to begin with an opening on the 6 findings for a variance with Ms. Henderson. If you'd like to go through that, or if you'd like to waive it, either way is fine.
I can waive that.
Okay. Ms. Reichard, do you have any opening?
Just briefly, that the proposed conditions that we submitted, we left a blank on number 3. I needed to confer with petitioner, and we'll insert 21 in number 3. And other than that, subject to compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
Okay, and so I think what we'll need for sure is a witness to testify that they agree with the conditions and can comply. And once we fill in that number of days, you want to go off the record to discuss it, or we can do that through?
No, we just, yeah, we can just, we had discussed it, so 21 is what we'll insert. And if they just give their agreement to the conditions,
Okay.
that should cover it.
Okay. Okay, so then, Ms. Henderson, if you'd like to call a witness for that purpose and any other evidence that you think might be missing, but given that there are no excess emissions, the usual additional findings we would need to make for the merits have been covered, I believe. But if there's anything else you think we need to know, we can have that admitted at this time through testimony.
I don't have additional evidence. I would like to call Mr. Scott just for the purpose of confirming that we agree to the proposed variance conditions.
We don't have to reintroduce Mr. Scott, but just, Mr. Scott, you're still under oath, correct?
Yes.
Okay.
Thank you, Mr. Scott. Have you had the chance to read the proposed variance conditions that were presented to us today by the district council?
Yes, I have.
And would you like him to summarize them, or they'll just be part of the record, so he doesn't need to do that?
I think we are fine
Okay.
with them.
Is SCE amenable to these conditions?
Yes, we are. One question on 4, if there are going to be no excess emissions, I was just questioning why that would be in there, but we'll happily give you reports of everything, by whatever date you need. That would be my only comment. And we're agreeable to the 21 days, as Ms. Henderson mentioned.
Okay.
Okay, and those are all your questions?
Yes.
Okay, Ms. Reichert, do you have any questions on that or anything else for Mr. Scott?
No questions.
Board members, anything else outstanding that you wish to have answered by Mr. Scott? And Mr. Scott, it is permit condition D29.5 that requires the quarterly source test, is that correct?
That's correct.
Okay. And in addition to Rule 3002C, you are also subject to Rule 203B with regard to following permit conditions?
Yes, that's right.
Okay, any other, you're a Title V, are you also wait, okay,
No, not a reclaim.
not a reclaim, okay. Just take 1 second just to make sure I don't have any other questions, and other board members as well. Did you, Mr. Balagopalan?
The 21 days, it's after the turbine is returned to service. Do you know, and I think Mr. Maddox said it's about a couple of weeks. Do you have any idea when you anticipate the turbine will be back in service?
I believe our latest information is still mid-January. So we have the source test tentatively scheduled, as I mentioned, for the 28th. So this gives a little leeway on that if it returns a little earlier than expected. So that was the basis for that. And I'd like to also note, I forgot to mention, we'd like calendar days to be mentioned in that as well. Or 21 days, 21 calendar days. Yeah. We're good? Okay.
Okay, thank you.
Senator.
The 21 days, how is that reflected in item number 24 of the petition? We want the effective date of the variance to be the 1st of January until the 31st. Is that all inclusive? The 21 days is all inclusive?
Yes.
Should it be so stated?
I'm sorry, the question is,
Should it?
does it go beyond, so what they're looking for, okay, so the date that you currently anticipate or still anticipate that the engine will be repaired is what?
I don't think we have a set date, but we've been told mid-January by General Electric.
Okay, so the 21 days would take you beyond January 31st, correct?
Right, and I think that was more so in case it comes back, say, January 7th, and we have a test scheduled for the 28th. That would give us a little more leeway.
So you would, if we started at January 1st and we went for 90 days, which is the maximum you can have under an interim variance, or until this matter could be heard for a noticed hearing, which is currently scheduled for the 14th, that would be what you're requesting, or something shorter?
I think that's sufficient.
Does that answer your question? Sorry?
Should we be specific about the date?
We will, during a motion. You mean for how long this variance will be in?
Right.
We would be very specific in a motion.
All right, thank you.
I had a question also, I guess for both, well, let me start with the witness, but there are no anticipated excess emissions, correct?
Correct, not operating, so we don't anticipate any excess emissions.
Okay, so you will not place it into operation until the test is conducted?
Well, I think there will be some sort of minor tuning that takes place as soon as it returns to service before the test, but we will minimize that operation.
Okay, and is that I'm looking at condition number 4, which has calculating, recording, and reporting all excess emissions. Are there, is it considered, maybe I'll just ask, are there excess emissions that will be considered excess because it will be placed into, the engine will be placed into service, not service, but into operation prior to the testing for tuning, and that would be considered excess emissions?
We don't anticipate any excess emissions during that time. Guess that would be my answer to that question.
I mean, I think the answer is there would be no excess emissions because you're not requesting any variance from an emission limit. You're just requesting a variance from the test date, correct?
Correct.
Okay, so can we remove that? And I'll ask Ms. Reichart that question.
Yes, that would be fine.
Okay. Yes, Ms. Verdugo-Peralta has.
Thank you, Madam Chair. I just want to clarify, so how long is your startup when you get that engine back? What period of time? A week, 2 weeks?
I think I would defer to Mr. Maddox on that question if you'd like us to call him back up. I'm not sure I'm comfortable answering that specifically.
I would, because I would like to know if that startup time, is there a possibility of there being any emissions? You're going to have the SCR also operating. It's all going to be during the startup period, but if in fact, I'm not comfortable removing 4 for that reason.
Well, let me just explain why I would remove 4. If there is any violation of any emission limit, then they would be in violation. This variance would not cover that. This variance, the request is simply for the test date to be a variance from the test date of by December 31st. And so with that variance, there are no excess emissions. If excess emissions occur, they have no coverage for it.
I'll leave it at that.
Did you have a question, Mr. Malcolm?
I think you stated it. Because they may be, but they're not getting coverage for that, so because Mr. Maddox said that I think they'll tune it and hopefully it'll pass, but we don't know. But they're not asking relief, so they won't get relief from that.
Senator?
Just you wrote the anatomy of a variance, everything's included there. And sometimes it's required to be specified.
Yes, are you at?
No, I just make, that's part of the motion.
Yes, it will be part of the motion. Also, I have a question. We have number 5, petitioner shall notify the clerk of the hearing board in writing when final compliance has been achieved. Is there a date by which we would be, maybe within, so many days of final compliance, or do we normally do that?
That could be open-ended.
Okay. Okay, so we'll just leave it that way. Okay, any other questions before we close the hearing? Okay. And Ms. Henderson, you had no other witnesses you wish?
No, thank you.
And Ms. Reckart, you are not planning to
No,
affirmatively?
no witnesses.
Okay. Then we're going to close the hearing, and Ms. Henderson, if you'd like to give a closing on the merits, you may, or you may waive it.
I'll waive in the interest of time. And
Thank you. Ms. Reckart?
I'll waive as well.
Okay. But there's no opposition?
No opposition.
Thank you. Okay. I think we could do this very fast because it's very similar to the findings we just were able to make for good cause, which is why we did not need much additional evidence. Again, we were able to find that there will be a violation as of January 1st of next year, and that is because we were able to find that the evidence shows that there will not be a working engine. The engine is working, but it's a safety hazard at this moment if it's operated, and it won't be repaired in time for the December 31st deadline. And we also heard evidence that the district, for various reasons, will not allow a swap of the engine with another engine in order to allow for testing to take place by December 31st. And that violation will be of permit condition D 29.5, which required that quarterly test for ammonia slip after the upgrades that were done at the end of 2018, and of course rules 203B and 3002C1, I believe.
Repeat that, I'm sorry.
203B and 3002C1, I think it's subsection 1, which are the two rules that require both Title V and just regular following of permit conditions. Beyond reasonable control, I think we made that finding already that this was not something that was known because it's not related to the intermittent issues with the SCR. This is problems with the engine, which were not found until that yearly borescope test that was performed in December when the damage was found and the repairs were required. And requiring compliance would either, number one, requiring compliance would mean they'd have to take this engine, which has safety issues, put it into operation in order to do the source test. That there's obvious reasons why that's a problem, and an arbitrary or unreasonable taking of property if it caused more damage or safety problems. But also, if we required them to comply and they did not wish to move forward with putting a dangerous, damaged piece of equipment into operation, there would be daily penalties that could accrue because they would be in violation. I believe that closing or taking would be without a corresponding benefit in reducing air contaminants because this peaker unit is not being operated and will not be operated until the source test can be conducted, except for tuning, et cetera, to bring it up to speed. But there are no anticipated excess emissions, and there is no request to go beyond any emission limit as part of this variance. Consideration to curtailing operations in lieu of obtaining a variance. In fact, they are completely, this unit is completely shut down because it has to undergo repairs, so there is no curtailment in lieu of obtaining a variance. Reducing excess emissions to the maximum extent feasible. Again, there are no excess emissions. It is out of compliance. It is out of operation. And finally, monitoring is not necessary. It, again, is out of operation. And we have conditions that are proposed, and I think those conditions all make sense, especially, well, including if we remove condition 4. So I can make all the findings, and I'm interested in other thoughts on the findings. Mr. Balagopalan.
I just wanted to clarify, no, that the equipment subject to this variance is a gas turbine unit, number 1, and it's identified device D1 in the permit. So it's not specifically an engine, but it's a gas turbine.
Oh, thank you. And it is that engine in the gas turbine, but you're right, it is the entire gas turbine. Any other thoughts?
Yeah, the variance is granted regarding the subsection. Do we include of the rule? To be precise, they say
We will.
subsection.
We will. There is no subsection. Well, there is. There is a subsection in terms of the rule that simply requires compliance with all permit conditions, and we will specify that.
Okay.
Okay. Any other thoughts? Ms. Verdugo-Peralta.
Thank you. Again, in regards to number 4, is there going to be any way to capture the information during the startup in regards to the emissions? I understand it's going to be taken out of this particular motion, but I still have a concern during the startup.
I think there's a SEMS, but do you want to open? Because I don't know if we took that down in evidence. Would you like us to open it up to make sure that there is a SEMS that would be recording all that data?
I would, just
Yes.
to answer that one question.
And there's 3 members who agree to just open for that one question?
Okay by me.
Okay, yes. Okay, so we're going to reopen. Mr. Scott is right there, ready to answer. Is there a SEMS that will be recording during the tuning and putting this engine back into operation at that time?
There is a SEMS.
And what
So
does the SEMS record?
So it will be recording the pounds per hour emissions and the concentration. So
And of what pollutants?
of NH3 and NOx.
Okay, so ammonia and NOx. Does that answer the question? Okay, great. Any other questions on that before I reclose the hearing? Okay, so the hearing is reclosed. Good question. Any other thoughts before I make a motion? Okay. In the matter of Southern California Edison, Barry Peaker, case number 1262-112, I move that we grant an interim variance beginning January 1st, 2020, and continuing for 90 days, or until this matter can be heard for a noticed hearing, which is currently scheduled for a short variance hearing on January 14th of 2020, whichever occurs first. And it will be for the facility that is located at 10670 Dale Avenue in Stanton, 90680. And it is for the turbine and equipment, the SCR that is attached to the turbine, that is referenced and noted on page 2 of the petition, item number 6. And it will be for the rules and permit conditions as follows: Rule 203B and Rule 3002C1, which require compliance with all permit conditions. And it is specifically with regard to permit condition D29.5, and it is further specified as listed in Exhibit A, which are the proposed variance condition, condition number 1, and it is with regard to the quarterly testing, source test, which was due or is due December 31st, 2019. I further move that we adopt the proposed variance conditions found in Exhibit A with the following changes. Condition number 3, we would insert 21, the number 21, in the open space. So it will be that there will be an NH3 slip test within 21 days of returning the turbine to service. Condition number 4 will be removed solely for the reason that there are no expected excess emissions with regard to the variance, which only covers the variance from the date by which they need to have a source test conducted, and the unit is out of service currently. So there are no excess emissions anticipated, and that completes my motion.
Second.
Dr. Bernstein seconds. Is there a discussion on that motion, Mr. Balagopalan?
And I know you mentioned earlier too, 3002C. I know when you made your motion.
Did I
you
have the wrong one?
No, you had the correct, but you didn't mention it, that's all. You mentioned permit condition 29.5, but not.
Oh, I thought I did. Okay, so it's rules 203B and 3002C1, if I didn't specify that, and specifically as relates to permit condition D29.5, and specifically as in condition number 1, it's with regard to the quarterly required source test. That's due on December 31st. Is that clear?
Yes.
Okay. Any other discussion then on that motion? Okay. Ms. Verdugo Peralta, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
Senator, how do you vote? Dr. Bernstein, how do you vote?
Aye.
I vote yes. Motion passes 5-0. Thank you very much. Got it done before lunch.
Thank you
Okay.
very much. We appreciate your time.
And we appreciate,
You did say, I think you mentioned, you said specifically, so I thought you were going to go through all that.
thank you. Is there any other business, board members? Okay, we are adjourned.